What would you describe as the major focus of the Act?
The Act was brought in to mainly deter or infuse the principles of Article 232 on values and principles of public officers, as read together even with Chapter 6 of the Constitution, and also Article 10 of our Constitution in terms of the principles and values for public officers in public service in general. And the Act came about to prevent the issue of public officers being entangled in their own matters or their own programs. Say, for example, if you are a public officer, you should not be involved in matters to deal with procurement within the entity that you work for. You should not use the information that comes before you or through your knowledge for any personal gain or used for your benefit or otherwise.
Okay, did it repeal the Public Officers Ethics Act?
Yes, it did.
Now, what would you, from your reading of the Act, what would you identify as its most transformative innovations, and how should courts interpret and enforce those provisions, innovations, to strengthen ethical governance? Can you just broadly tell us what are the main provisions and innovations that are different from what was in the old Act?
The main provision in the Conflict of Interest Act, as I've said earlier, was to deal with interference of public officers on matters that come before them in their day-to-day life.
What I mean is that,
yes,
that is the same thing the old Act, the Public Officers Ethics Act, provided for. However, in the new Act, there are new innovations that have been brought about. For example, it has expanded the interpretation of conflict of interest. Mm-hmm. So what are the other new things, transformative things that have been brought in by this new Act that we don't find in the old Act?
Matters to deal with conflict of interest also extend to direct members of family who are dealing or who are have
apart from expanding the definition, are there other provisions that are transformative or innovative?
Yes, I believe there are other provisions within the law.
Like which one?
You're talking about issues to deal with ethics and high levels of standard, in synonymous with the principles under Article 232 in terms of.
Does it create any offenses?
Yes, it does create offenses.
Which ones?
It does create offenses.
Which ones?
The offense of
anyway.
There's offense on withholding of information that is known to you if it is disclosed in a manner that is not appropriate.
When the Act focuses primarily on public officers,
yes,
its implications for legal practitioners are very significant, given the frequency with which legal practitioners, advocates interact with public institutions, offices, in the discharge of their profession. So would you be able to just tell us generally what are the implications to legal practitioners of this Act, who are not necessarily public servants, and sometimes also public servants?
I believe in the course of one's duty as an advocate, you are bound by issues to deal with confidence, and in matters where there is a breach or matters where something is known that is contrary to the law, especially when you're dealing with issues of money laundering or such items. For legal practitioner, the conflict of interest, one should be able to disclose where the source of these monies that are coming in one's account. And this disclosure has an effect in as far as the duty of advocate-client privilege is concerned.
Okay, as the county solicitor, have you taken time to sensitize your people about the act, the implications, the offenses that have been created there and the sentences?
Yes, the act being recently enforced, we have worked on a program together with the County Public Service Board to ensure that all members of staff within the institution are sensitized, and we have a work plan to ensure that that program is articulated in a manner that the workers or employees of the institution are knowledgeable about these offenses. And
do you think that this act can have a positive effect to governance at the county level?
Yes, I believe it would have a positive effect generally, because it will instill core values that are enshrined in the Constitution and infuse them into the public service. And through such programs where there's the general sensitization, I believe people will become more aware about some of these offenses and align accordingly when it comes to public service.
And finally, now, if you become a judge, how would this act help you?
The Conflict of Interest Act, if I become a judge, will be integral in as far as my dealing or how I conduct myself in matters. I should be able to breed confidence into the institution. I should also be aware about how I interact with other people and other parties in various matters, and and in areas where conflict would arise, I should be able to make a disclosure even before it is prompted.
Thank you. Thank you.
Thank you. Yes, the Shisha.
Thank you. Thank you, Honorable Chair. Mr. Chipinde.
Yes, my lady.
The civil procedure rules make provision for amendment of pleadings. Are you aware of this?
Yes, I am aware.
What does it say about amendment of pleadings?
Pleadings can be amended through application or before they've been served, and while the summons, during the period of the summons, one can be able to amend the pleadings at that instant, or in the course of the trial or the suit, a party can be able to apply to disclose how they want their pleadings to be amended, and that disclosure must be made known to the other parties in a manner that they will be able to appreciate, especially
what disclosure?
The disclosure in terms of what they are either striking out, what they are adding in the pleadings that were filed beforehand.